And why proceed?
Much
Can I put my photo visual? Can you please please let's extend the same grace? But also we had asked that if they are holding mics, please make sure the sanitizers are on. I've noticed people have it. And you get it. Thank you.
Much obliged, my lady and my lords. Before I proceed, my lady, my lords, there were some few issues that we needed clarification from the bench. The first one is the order of addresses in terms of after we submit as the applicants in respect to the amicus, what would be the order of addresses? If they submit immediately after the applicants, or they will submit after the court has made the responses from the respondent.
Which ones?
Yes.
Okay.
And then also whether the respondents are going to make their oral responses today, or that will be made on the first day. Is a 15-year-old boy who stands currently charged with the offense of defilement under section 138, 1 of the Penal Code. It is alleged that he was in a romantic relationship with a girl of 13 years of age. And had consensual sex with her on 1st January 2021.
21st or 1st?
1st January, yeah. It was on the same 1st January 2021 that he was arrested after the parents of the girl reported the matter to the police in Cholo. And he was taken into custody from 1st January to 9th January 2021.
Yes.
When he was eventually brought before Cholo Magistrate Court, where he was formally charged with the offense of defilement. Contrary to section 138, 1 of the Penal Code. And the court subsequently granted him bail, and he remains on bail until now, on court bail until now. The applicant sought criminal review before the High Court, challenging the offense of defilement under section 138, 1 of the Penal Code, as it applies to consensual adolescent sex relationship.
Yes.
My lady, my lords, before I proceed, I've been advised that Counsel Cho wanted to address the court.
Okay.
Yeah.
My lady and my lords, if I understood correctly, amicus will be making submissions on the 1st of March.
Yes.
On the initial scheduling, we thought we would be done by around midday, and I had scheduled a departmental meeting at the University of Malawi Chancellor College this afternoon. Now, in the event, I would be seeking the court's permission to allow me to take leave so I can attend that meeting. I will have the full benefit of submissions by the parties, and so that our submissions, when we come to address the court, are not going to be redundant.
All right.
Much obliged, my lord.
We have no issues. We can allow you to take leave.
Much obliged, my lady.
Permission to proceed?
Yeah, sit.
Thank you, my lady. My lady would have to state at the outset that the issue before this court is not about whether children should engage in sex or not.
Yes.
The issue before this court, my lady, is whether it is constitutionally right or correct to subject children to criminal sanctions for engaging in developmental sexual conduct.
Yes.
The issue, my lady, my lords, is whether it is proper to subject children to criminalization for merely doing what is normal for children at their age when they are growing up.
Yes.
My lady, the applicants are rights holders by virtue of being human, and therefore are entitled to enjoyment of all the rights that are enshrined in our Constitution.
Yes.
My lady, you will notice that Section 138(1) of the Penal Code creates a strict liability offense for sexual intercourse with a girl under the age of 16.
Yes.
My lady, the provisions of 138(1) of the Penal Code should be contrasted with provisions of Section 160B of the Penal Code, which all deal with children. And you will see and notice, my lady, that Section 180B of the Penal Code was framed in a neutral manner to protect both the girl and the boy child. Yes, my lady. Section 160B of the Penal Code. However, the acts targeted under 160B are short of sexual intercourse. One 138(1) of the Penal Code only protects the girl child. You will notice, my lady, my lords, that in our skeletal arguments, we've made reference to an article which was written by Dr. Godfrey Gangaude, which is titled Adolescent Sex and Defilement in Malawi Law and Society, which is reported in 2017, volume 17 of the African Human Rights Law Journal at page 527 to 549. Yes. Dr. Gangaude, in that article, my lady, my lords, he argues that the rationale behind the offense under section 138(1) of the Penal Code was not necessarily to protect the girl child, but rather to keep the girl child pure in order to increase the prospects for marriage for the girl child. The applicants are inclined to agree with Dr. Gangaude on this position because, my lady, my lords, when you look at the Oxford Dictionary definition of the word defile, it actually means the action of spoiling something or someone, or making something less beautiful or pure. Yes. And this argument, my lord, my lady, my lords, is also supported by the fact that section 138(1) of the Penal Code is not gender neutral. It only protects the girl child. If at all the intention of the framers or the history of the offense of defilement was to protect the girl child as it should, then it shouldn't have left the boy child to be protected under the same provision. My lady, my lords, by saying that, it doesn't mean that we are advocating that both girl children and boy children should be criminalized. No. Our argument is that should criminalization of adolescent sex be the response to early child sexual activity? My learned colleague here submitted before this court the rights that are violated in the application of this law in the broad sense as it applies to even consensual, non-exploitative sexual relationships between adolescents. Further to that, my lady, my lords, we are also not saying that children cannot commit the offense of defilement. We are not saying that. What we are submitting before this court is a scenario or a situation where children growing up fall into innocent sexual relationship and they engage into sexual intercourse. Should the law criminalize that innocent sexual relationship. Having said that, my lady, my lords, that goes to the issue of the right to dignity of the child. The first applicant has relied on the case of Maisogwanda versus the state, in which the court in that case stated that recognizing a right to dignity is an acknowledgement of the intrinsic worth of human beings. Human beings are entitled to be treated as worthy of respect and concern. My lady, my lord, this applies even to children by virtue of being human beings. They need to be treated with respect and concern. In the African Commission on Human and People's Rights, in the case of Fulod and another versus the Gambia, which is referred on paragraph 4.35 of our skeletal arguments, the court in that case also notes that human dignity is an inherent basic right. Which all human beings, regardless of their mental capabilities or disabilities, are entitled to enjoy without discrimination. The fact that one is a child, my lady, my lord, it doesn't take away the dignity of that child to the extent that law enforcement officers should be allowed to go in the bedroom of the children and enforce the law for doing something that is essentially normal at that stage of growth of a child. My lady, my lords, the applicant also submits that the rights of children are not dependent on their parents. And these rights are not just held in thin air until they reach a certain age. They are rights that have to be enjoyed even at the time when they are minors. My lady, if one's consensual sex choices are not respected by society but are criminalized, it means that one's intimate sense of self-worth will be...
Can you please repeat that?
My lady, I was saying that if one's consensual sexual choices are not respected by society but are criminalized, then one's intimate sense of worth, of self-worth, will inevitably be diminished, my lady, my lords. by publicly exposing adolescents, like the applicants in this case, to prosecution, would bring smear of their character, and they will be rebuked by their peers because of the criminal element attached to the sexual, the consensual sex between adolescents. My lady, my lords, on that point, I will refer the court to look at the case of S versus M. This is the South African case, which is on, in our scheduled arguments, is on paragraph 4.3.8. My lady, my lord,
Yes.
we cannot ignore the reality of consensual sex among teenagers, and that it will be wrong as the law it is now to overly approach the issue of teenage sex by criminalizing every sex conduct without taking into account whether it is consensual or non-consensual. We submit therefore that the applicant's right to dignity has been violated by section 138(1) of the Penal Code, as he has been subjected to criminal justice at his young age, having spent a week in a police cell and traumatized by that experience, only for engaging in consensual sex with a girl within the same age range. And he has obviously, my lady, suffered trauma and shame and stigmatization from his peers. As a result of the going through the criminal justice system. Council Kilembe already addressed the court on the right to equality. I just wanted to point out one or two things on that, but I will not dwell much on it because it has already been addressed. The first applicant argues in respect to the right to equality that there is indirect discrimination in the application or by the law under section 138 of the Penal Code in that the applicant and adolescent children, by virtue of the law, have an equal access to sexually productive health services because the law as it is pushes them underground for fear of facing criminal sanctions if they come out with nation.
Yes.
Section 138, 1 of the Penal Code, as it is, makes it my lady sexual reproductive health services because they fear that they will be criminalized on the boys' part in particular.
Yes.
My lady, allow me to address you on the best interest of the child. We have submitted in our skeletal arguments that the provisions of Section 138(1) of the Penal Code, contrary to the a tool for interpretation of statutes, legislation, policies, and even budgetary decisions. And also, lastly, that all decisions involving children, whether they are involving a group or one individual, the rule is a guideline by making both assessments in terms of the positive and the negative impact of the decision that will affect the child. In essence, what the committee is calling upon is to say that every decision concerning children, it must take into account the best interest of the child, understanding what that best interest of the child is, and also outlining clearly what criteria has been used to reach that decision that is in the best interest of the child, and also how the child's interests have been evaluated against other considerations. The applicant argues, my lady, my lords, that the best interest of the child in this particular case requires avoiding the criminal justice system as far as possible. The best interest of the child, my lord, my lady, my lords, requires that the adolescent children should be protected from the negative consequences of the criminal justice system, as this has an impact on their education, development, both physical and mental health, and is generally hazardous to their general development. My lady, my lords, I invite the court to look at the cases of Francis Capo Francis Capo and 7 others, which is referred on paragraph 4.7.6 of our skeletal argument, and also the case of Republic versus Children in Detention at Vumbwe and Kachere Prison, which is referred to in paragraph 4.7.7 of our skeletal argument. In both cases, the court makes a point in terms of how harmful imprisonment or detention of children is to their health, physical, and mental development. And we therefore submit, my lady, my lords, that it is not in the best interest of the child to respond to adolescent sex, consensual adolescent sex, by criminalization. My learned colleague, Council Kilembe, made reference to some of the statutory provisions or the position of the law in respect to issues of consensual adolescent sex in the region. But I'll also draw the attention of the court to look at other jurisdictions outside the region, which we have stated in our skeletal arguments. You will notice we have included the United Kingdom, we have also included Canada, Finland, and Sweden. Although all these are legislative provisions, it helps this court to understand how other jurisdictions have approached the issue of consensual sex between adolescents. And what runs through all these provisions is that in all these countries, they have not criminalized consensual sex between adolescents. What they have done is to look at issues of exploitation, even among young children. If there is an element of exploitation among the other, that has been an element to warrant prosecution. But generally, where there has been no exploitation and the parties involved are within the same or close age range, the courts or the statutes have essentially not criminalized that type of sexual activity. My lady, my lords, in terms of the remedies that the first applicant seeks before this court, the applicant seeks that this court gives effective remedies to the violation of the rights that have been stated before this court by myself and also by Council Kilembe. My lady, my lords, the applicant is not seeking a wholesale repeal of the offense of defilement, as the offense has a function to protect against sexual exploitation. However, this court must give effective remedy
Council, you have 20 minutes left.
much obliged. That has to make the effective remedy, that has to make an order to preserve the progressive function of the offense whilst ridding it of its destructive components as argued by the applicants. The applicant.
Can you repeat that?
I will take that again. The applicant argues that the court should give an effective remedy, and that effective remedy has to be an order that preserves the progressive function of the offense. The progressive function is the protection side of it, whilst ridding of its destructive components, which is the criminalization of innocent sexual conduct, which results in the violation of the rights as argued. The applicant wants his rights, the first applicant wants his rights to be vindicated by the court, whilst requiring that there should be an amendment within a reasonable time of the law to repeal the parts or to amend the act, the provision rather, to the extent that it violates the rights of the applicant. The applicant seeks that Section 138, one of the Penal Code, should be construed by this court construed inconsistent with the Constitution and find that it violates the rights as argued by the applicant. It is also the applicant's prayer that if this Honorable Court orders that Section 138(1) of the Penal Code, to the extent that it deals with consensual acts between adolescents, is unconstitutional, the adolescents that have been convicted under this provision should be entitled to apply to have their convictions reviewed in order to determine the nature of the relationship and sexual encounter. It is therefore our prayer that this court makes the orders that the applicant seek, that is declaring Section 138(1) of the Penal Code unconstitutional to the extent that it applies to consensual and non-exploitative sexual relationship between adolescent children within the same age range, and also that it violates the applicant's rights as submitted before this court, and that the prosecution of the applicant in the circumstance is unconstitutional and therefore must be permanently stayed. That will be all, my lady, my lords.
All right. Justice Meriva, do you have any questions? Mrs. Mamlas? I know you had a few. For now, okay? I think I'll leave mine until we get to the responses you will make after amicus, because there's a question I have, but it has to be addressed within that confine in terms of your own order. So, Counsel for Attorney General, your response, you've got the next hour.
Marshal Brecht, my lady, and my lords. My lady and my lords, would like to seek for a 10-minute adjournment. That is a healthy break. We have run out of energy levels. Just want to re-energize ourselves.
All right. Maybe I should ask, do people want to go eat lunch? Can we do a 30-minute lunch? Are people able to eat in 30 minutes?
Yes. That is in order, my lady.
I understand. Okay, maybe I'm taking my own experience of being a nursing student who used to be able to eat on the go within 10 minutes. So I'm being informed by my brother judges that I'm being too harsh with you by giving you 30 minutes. So maybe let's take it an hour. We come